Welcome back, and thank you for joining A Shark's Perspective. I'm Kenneth Shark Kinney, your host and Chief Shark Officer. Let me tell you first about two amazing sponsors who make this show possible. Let's talk about Inbound. From marketing to sales and commerce to CX, Invoca's active conversation intelligence platform enables revenue teams to create better buying experiences, drive more leads, and increase revenue. Trusted by top brands like Dish Network, Mayo Clinic, Mutual of Omaha, and ADT, the Invoca team is doing some amazing work in turning conversational data into automated action to enhance digital touchpoints and human interaction. Next, let's talk about Outbound. I hope that you'll take a look at Drips, the founders of conversational texting, where they use conversational AI to help you reach customers where they're most responsive, and that's on their phones. And working with major brands like 3 Day Blinds, Liberty Mutual, Credit Repair, and Gainsco, Drips is leading the way for some of the biggest brands in the world to improve engagement rates and outcomes for their prospects and customers. And now back to the show. Do consumers want your calls? For brands and especially marketers from those brands, it can be easy to not understand a very complex minefield with how we should call or not call consumers. Just out of respecting data and consent is one part, but respecting the legal guardrails is another, especially for those of us who live in the performance marketing space. For a lot of brands, the waters are murky and unfamiliar with calling consumers the right and legal way. Michele Shuster is a founding partner of Mac Murray Shuster, where she advises clients on proactively managing federal and state consumer protection demands. She's the Regulatory Counsel to LeadsCouncil, as well as the General Counsel to PACE, the Professional Association for Customer Engagement. And on this episode, we'll discuss TCPA, Consumer Protection and Do Not Call laws, states picking up where federal regulations may leave off, ATDSs, and random sequential dialing, footnote 7, stir shaken, call limits and the debt collection rule, enhanced caller IDs, the traceback group, diving in the Adriatic, Bearcats and white tips, and a lot more. So let's tune into a leading TCPA attorney and a shark who only observes best practices whenever he calls on this episode of A Shark's Perspective. Michele, thank you so much for joining us today on A Shark's Perspective. I got a chance to meet you at a conference and through our mutual friends with LeadsCouncil, and especially all the folks in the performance marketing world. And I know about your background, but tell us a little bit about yourself, your background, your career to date.
Sure. So I'm a founding partner of my law firm, Mac Murray Shuster. We're located in Columbus, Ohio. We have a staff of about 25. We're primarily in the marketing and advertising space, and a large percentage of my work is in the telemarketing space. I was the consumer protection chief for the Ohio Attorney General's office for a number of years. And then after leaving the AG's office, went to work for big law firms and took that knowledge I learned about enforcing regulations to help companies defend themselves against lawsuits, and also to assist them with compliance so they don't end up in lawsuits to begin with. I'm currently General Counsel for PACE, the Professional Association for Customer Engagement, which is the trade association that represents contact centers and all phases of contacting consumers. And I'm also Regulatory Counsel for LeadsCouncil.
Yeah, that's a lot of hats. So the thing that I really wanted to cover a lot today was where we are with the state of the state with all the regulations. Where are we today with current regulations as they stand? Over the course of 2021, we've obviously seen the Facebook ruling and how that got narrowly defined by the Supreme Court. But now we're starting to see a lot of things change with state laws. For example, California and Florida just passed an act which went into effect in July of 21. Arizona's starting to do some things. You've got one Supreme Court ruling, and then you've got 50 different regulations. How narrow or broad should we think about this from a state perspective?
Well, so, states have had regulations similar to the TCPA for a very long time. When the federal agencies, the Federal Trade Commission and the Federal Communications Commission started passing or implementing, I should say, do not call regulations, the states followed suit. So, I can tell you, having headed or led the consumer protection section for a state during the time when do not call laws were passed, the states and the federal agencies work very closely together. So as we see a deterioration maybe in the breadth of what the TCPA covers, we are certainly going to see states pick up that slack, and we're already starting to see that. You've mentioned a few of those states. California probably being the most significant, which changed its telemarketing regulations back in July, effective July 1st. What we're seeing that's common in these states is they're more broadly defining the type of equipment that can be used that would implicate the statute. So you mentioned Facebook had limited the scope of the Telephone Consumer Protection Act, or the TCPA's definition of a dialer, to one that is actually using a random or sequential number generator to store or to call telephone numbers. Well, the states are not taking that, that narrow approach. Florida, for instance, is looking at systems that automatically dial telephone numbers or choose telephone numbers for dialing. So, that's not something that we've looked at previously. We don't have any case law. And so we definitely don't want our clients, we don't want your listeners to be the test cases in Florida. So it's a very important point in time to stop, look and see what type of calls you're making. Find qualified professionals who understand this industry, and then make sure you have a defendable position, because if, God forbid, you are brought into one of these lawsuits, you're going to want to make sure that you're able to get out of them quickly. So yeah, the landscape is definitely changing. We're going to see a lot more focus on states. We are going into murky and unfamiliar waters, as the shark would know. And so it's just really important that you're prepared and that you know what dangers to look for as you're marketing and making calls.
Who are the types of brands that are typically getting themselves into this kind of trouble frequently?
Well, of course, I don't represent bad actors.
Yes, no, only the best.
Maybe got some bad advice in the past from different counsel, or folks that just had trouble getting through all of the details of all of the regulations that apply when you're marketing direct to consumers. There are so many regulations to consider. We've got all of the do not call provisions that we've talked about. We've got regulations that dictate the mode and medium that you can use to contact consumers without consent. You have privacy regulations now, depending upon whether you're texting or making telephone calls. There are various requirements and best practices, especially in the texting space. So, it's not that they're bad actors. It's that this is a very confusing area of the law. Not all of the regulations that are imposed on business make sense. And a lot of them don't even have a definitive term associated with compliance. The ATDS definition under the TCPA is a great example of that. And even with the Supreme Court ruling on what the definition of an ATDS is, as a result of a footnote 7, which we can certainly talk about, there's still some confusion, and intelligent people can argue, and they are right now, plaintiffs and defense counsel, about what that means. So I wouldn't say that it's bad actors. The folks in the space that are problematic, that aren't following the laws, don't have much concern, and we don't see them in court because you can't get to them, are the folks, and generally these are overseas, they're using pre-recorded messages to initiate contact with consumers in the United States, and they're causing a tremendous amount of problem because if calls are being placed to consumers that they don't want to receive, and if these are spam calls, robocalls, whatever you want to call them, then that's making consumers not pick up their phone at all if they don't recognize a phone number. So those are the ones that are extremely problematic. Consumers do want to receive calls that they expect, that they've requested, and those kind of bad actors are making it difficult for the rest of the community.
Well, I've only got the smartest and brightest listeners on the planet, but define what an ATDS is in the modern era.
Yeah. So just to back up here a little bit. So the TCPA was originally passed in the mid 1990s, and it was passed because we had really smart telemarketers that had figured out how to produce dialing systems that they could literally just start with dialing and sequential numbers with all zeros, ending with all nines. And in doing so, they would tie up literally every phone in a hospital or a police station or IBM or whoever that had purchased blocks of sequential phone numbers. Or they were just, dialing from a phone book randomly. There was no consent involved. They weren't targeted leads or consumer requests to place telephone calls. And so the TCPA was passed in order to, or the regulations were passed in order to specifically address that. And so, basically an automatic telephone dialing system is a system that uses a random or sequential number generator to either store or produce those numbers that are created and then calls them. In Facebook, which as General Counsel for PACE, we were involved and submitted an amicus brief that specifically addressed the issue of storing and producing telephone numbers that had been randomly or sequentially generated, because the argument had been made in courts that it didn't make any sense for a random and sequential number generator to store the telephone numbers. If they were going to produce random and sequential numbers, they were just dialing them immediately. But we were able to find a patent that existed prior to the TCPA regulations that specifically showed that you could use a random and sequential, and did use a random and sequential number generator to store telephone numbers before calling them. So the Supreme Court relied heavily on that brief when it issued its decision that you actually have to use a random and sequential number generator to store and to produce and or store those telephone numbers before calling them, as opposed to just dialing from lists without any type of human intervention. But what the problem with the Facebook case is, there's this footnote 7 that also referenced our patent, and the court was trying to explain why it wasn't irrelevant that a ATDS could, or a random and sequential number generator could, store telephone numbers. And so it referred to that patent where it talked about sequencing numbers before dialing them. And so plaintiffs' counsel have really latched on to that sequential generation of numbers happening and then dialing them. And, the issue with that is that's such a broad definition or concept that really any cell phone could be brought into that, because the way computers work is they index phone numbers in some type of sequential fashion that makes sense to whatever the role is of the dialing of that telephone number. So we're starting to see some case law that is going both ways. I think the long and short of that issue is it's probably not a motion to dismiss. So you're probably not going to get out early on that issue. So you still have to be very careful. You should still have your dialers looked at. You should get dialer opinions on whether it's an ATDS or not. I would also say, for anybody out there who's listening to this that is having an issue with that footnote 7 from Facebook, we filed another amicus brief in the Huffness versus Do Not Pay case that lays out the argument as to why footnote 7 was not talking about just the sequential generation of numbers, but was just more specifically talking about the patent that we had submitted. And so if anybody needs that, feel free to reach out to me. Happy to provide it to you, or you could look up the Huffness versus Do Not Pay, which was decided by the Northern District of California.
We're obviously having a lot of challenges for brands, for call centers, marketing teams, so forth, to get their calls through to potential customers. What are the biggest challenges today that you see from a legislative standpoint for these brands? And what are the opportunities you see from a lawyer's perspective for how they tackle those and move forward to be able to connect with their customers?
Sure. Well, privacy is going to be the biggest issue moving forward. We're talking about dialing systems now, but soon it's going to be only privacy that we're talking about. Virginia just passed a new state privacy law that has a private right of action. We all know about the CCPA out of California. Nevada's made some changes to their privacy statute. And so really what we're going to be talking about soon is the right to be able to use the information that we collect and who that can be shared with. What type of options you need to give to consumers to opt out of the sharing of their data, and how you have to honor that. So, I think it used to be that privacy was an afterthought once you put a website together and asked for information and started collecting that consumer information, and that will no longer be as we move forward. This term of privacy by design is something that everybody should be thinking about, and should be thinking about how they're collecting information and what disclosures they're required to make, and how they can handle and share that information, and how they have to honor the requests to have that information deleted. So big issue moving forward. Just from the consent perspective, though, as we're looking at affiliate marketing, lead generation, whatever you would like to call it, consent is going to be the big issue. And it's going to be a big issue for two reasons. One, because states are looking at what consent requirements will be imposed by those states. And so it might not be the same requirements for consent as the TCPA. So you really have to understand how you can get consent. So that's one. Two, some of the states are requiring that you also specifically get consent for text messages. It's not no longer adequate to just say you're giving consent to contact that or that consumer is giving consent to be contacted. It's got to be by that specific medium of contact. And then also, the technology is changing now. There's this new requirement that's called Stir Shaken that was put into effect starting June 30th. And it's something that I'm sure most of your listeners, because they are very smart, are already aware of. But now we have telecom carriers that are regulating what kind of messages can get out there. And specifically, a level of trust, it's called an attestation level between an A through C, so A, B, or C, will dictate whether phone numbers or phone calls or text messages are blocked or labeled as spam or telemarketing or robocall or something to that effect. When the consumer receives those. And so the key component there is you got to work with your telecom carriers or your voice service providers so they know who you are and they know that you have the right to use the caller ID or telephone number that you are using. So you'll get an A-level attestation, because if you don't, it is going to be very difficult to get your telephone calls or texts through to the intended recipient. So just a lot of stuff going on right now, and it literally changes daily.
I could ask you the same question in 5-10 years. It'd be a lot of stuff going on, and it continues to change daily, especially as technology keeps going. But going back to consent a little bit, what is a best practice for people that you see that they're not taking advantage of with consent? In particular, I often, at least in my small opinion, think of the way that a lot of people collect information. Seems to be fragmented by channel, but then they blast it out across channels in the wrong way. You may gather consent for Facebook, but then you abuse somebody on email. You know what I mean by that?
Sure. No, I know exactly what you're saying. And and I think it's implied in your question as well. We have companies that are generating consumer information to provide to others to contact them about various products or services. Maybe it's mortgage companies. I think that's probably a good one. We have a lot of marketers out there that are very good at accepting consumer information and determining which mortgage company would be best for a consumer based on a number of factors, from credit rating to area of the country to type of loan that they're looking for. And so, in that context, and that obviously you can apply the principles broader, but the best practices would be if we have a web page that's collecting consumer information for consumers who are looking at that specific industry when they're providing their information. So they have, a single source kind of web page and dedicated only to mortgage providers. And we don't also then have a marketing partners list that has literally thousands of marketing partners that don't have anything to do with mortgage information. So, if we have those, that single path of consent that is providing consent for a specific industry, And then a specific seller would be the absolute best practice. But there are ways that you can generate consent for multiple companies, multiple sellers through that path. But again, just in a nutshell, what's most important is when you're getting consent from a consumer, it needs to be clear and conspicuous to that consumer that they're providing consent for whatever you're going to do with that information next. If it's telephone calls, then telephone calls, text messages, text messages. If it's email, then let them know it's email. But now the consumer should understand what providing their information is going to lead to. And from the non-legal perspective, we should just start with that.
One of the biggest challenges, especially for call centers in particular, that we run into is somebody's either filled out a form or they've given some sort of consent, and then we start calling them, and we start calling them again, and companies start calling them again and again and again. How should someone effectively approach call limits with how often they should be calling a potential customer?
Yeah. It's a question we used to get a lot before regulations started coming onto the book. What's the best practice for call frequencies and limits? And then, gosh, has it been over 2 years ago now? The CFPB proposed the new debt collection rule, and that limits debt collection calls to 7 calls in 7 days. So that was where we started seeing call limits being regulated. And then the FCC has limited calls to 3 in a month for certain types of calls that were otherwise exempt from the TCPA's consent requirements because of by rule or by decision the FCC had exempted them. They're limiting, as I said, 3 calls in 1 month. So that is another set of call limits that we saw in Florida. They're imposing call limits as well. And so you can't place more than 3 calls within a 24-hour period. And so the trend is there, and call limits, call frequency is going to be an issue moving forward. We definitely don't want to overcall consumers. They stop answering the phone when that happens. And I think you could look to, probably the debt collection rule, the 7 calls in 7 days. I think that is something that makes sense, except, if you're calling in Florida, you're going to want to make sure you don't have more than 3 of those in a 24-hour period. But this is one of those things, at our law firm, we call ourselves the 50-state survey queens because we end up providing advice on how to comply with all 50 states. And usually, businesses will opt to comply with the most onerous, or if it's too onerous, they'll skip that state. But at least they have a way of understanding that by taking certain steps, they're going to be complying with most of the state regulations, and then staying out of the states that would be problematic. But I don't know what the magic number is. I know from the guidelines that we're getting what we're looking at, but I don't think that, consumers are looking to get more than a handful of calls in any single week.
What actions should someone take if you're working for a brand as to, reasonable action to prevent robocalls, how they measure that? Because if something does come up, they're going to need to prove it.
Yeah. So really important to understand that the regulations require that companies have documented policies and procedures for complying with do not call and, with the relevant regulations. So just really critically important that you've looked at your business process and you've put together policies and procedures designed to comply with the law. And then once you've done that, it's critically important that you audit against those policies and procedures. Are people actually following them? So for instance, when you're initiating a campaign, has that due diligence list already been gone through? Has the script been analyzed to make sure you have the proper disclosures? Has the list been scrubbed based on the type of consent that you have? Have you tested that consent to make sure that you can validate that you have consent? So, did that campaign get initiated in a way that followed your policies and procedures? And then, the most important thing is if you receive complaints, we call those golden tickets, because if you receive a complaint from a consumer, they are telling you that you have done something wrong, and that gives you the opportunity to fix it. So instead of being annoyed when you receive a consumer complaint, really have to focus on what it's saying and how that gives you information about how you can prevent annoyance to consumers, which leads to complaints. Or if you decide that there was a compliance gap, how you can fix that compliance gap. And then when you discover that there are issues, you've got to proactively act to change those immediately. Because once you have knowledge of issues, then it can become much more problematic in a litigation scenario. I would say that there are other platforms out there that you can check to make sure that your telephone numbers aren't generating consumer complaints. The FTC has a call database that you can go to and check your phone numbers to see if they're receiving consumer complaints. The FCC has just initiated a database that businesses can file complaints against illegal calls that are being made, or unwanted calls really at this point also. Various AG's office will also have portals that you can check for consumer complaints. The Better Business Bureau, all AGs work with the Better Business Bureau in determining if they're going to take an enforcement action. So your BBB rating, and more importantly, that you respond to complaints, is just really critically important. So, that's what should be at the heart of all compliance programs.
So we do all this from a legal and legislative standpoint in order to protect consumers, which is what we need to do. But when is call blocking an actual harm to a consumer? Because that's got to come up as well. I mean, you can overregulate, or it's almost like you're over medicating your internal actions if you're a good actor.
Yeah. So, of course, over the last couple of years, I have heard of hundreds of situations that call blocking could or has led to issues. Probably one of the worst in my mind that I heard was somebody who was on vacation, and they had one credit card with them, and there was a fraud alert that was sent to her. And because that call was labeled as fraud likely, she didn't answer the telephone call, and so that credit card got canceled, and then she couldn't get it turned back on until after she got back to home. So it led to some pretty significant issues to her. But we've talked about with regulators, if you have loved ones traveling abroad, and God forbid they have some type of medical issue, and somebody overseas is trying to contact you about that. Under our new STIR/SHAKEN framework, that might get the C-level attestation that would keep that call from coming through. It would get blocked, and you'd miss that call. And the response I got from one regulator is that you can't protect consumers from themselves. So that's the kind of response we get. But there are all kinds of situations where blocking and labeling could be an issue. I will say that the telecom carriers are working on best practices for remediation of wrongly blocked or labeled numbers. So at the larger enterprise level, that will make a difference. On these one-off calls that I just talked about, that won't make a difference. And all new cell phone subscribers who are signing up have signed up, unless they opt out, to blocking of calls at the carrier label or level. So it's an area that you definitely need to be familiar with from the legal perspective, but also just from what's happening out there in the telecommunications space with really unregulated denial of access for certain companies to the phone networks.
So this question is going to be hard for me to ask an attorney the right way, but because I know the perspective somewhat that you're coming from as well, but are we making this entire process too complex? I mean, it almost seems like for a lot of companies, although there are some processes to document through, if you try to actually write out the matrix that makes up the call landscape from a legislative and legal standpoint, it's a massive mess, and it's hard for a lot of people to navigate, even if they have in-house counsel.
It is definitely complex. the laws and regulations out there are not easy to follow and contradictory, even in some situations. So no, this is not an easy area to navigate. I think that it's going to get worse because I think that Stir Shaken is going to go a long way to preventing bad actors access to the telecommunications network. I think that will help tremendously. It was designed to help. But in the meantime, we have states that are now passing their own regulations, and I think frequently outside of the context of Stir Shaken and what it is going to be able to do. And so we're going to have regulations that are going to do nothing except harm legitimate business because the lawsuits are against legitimate business. Sometimes the mom and pop stores on Main Street that didn't understand that there were these complicated regulations. And so, you know, it's an area as an advocate for the contact centers in the United States, you know, representing PACE, that we frequently are speaking to regulators about and trying to, you know, guide policy and try to stop needless regulations that will only harm legitimate businesses and not stop any of the bad actors from making telephone calls. And we really have to get the regulators to understand that.
Well, and I know we covered it a little bit earlier, but broadly define briefly, if you will, what Stir Shaken is.
So Stir Shaken is a system that was designed to establish trust in the telecommunications network again. So basically at its basest level, anybody who's originating a telephone call will be required to provide a token that travels with that phone call or that text in a SIP header. And the token will either, it'll provide other information, but relevant to this conversation, it will say whether the call originator knows who's placing the telephone call and if they have the right to use the telephone number that they're using for caller ID. If they do, they get an A-level attestation, which those calls are going to get through. If they only know that the telephone number that's being used, they know who owns it, but they don't know if they have the right to use that telephone number. And the situation where this can occur is in the enterprise setting. So you have contact centers that have DIDs that they use. They work with multiple carriers. They know that that contact center has the right to use the telephone number, but they don't know anything about the campaign that they're making and whether, for instance, a caller ID that would go to the customer service number of the company that they're calling on behalf of. They don't know if that caller ID is something they have the right to use. So that could lead to a B-level attestation if a business isn't managing that correctly. And then the C-level attestation mostly applies to overseas calls or when you have no information about the call that's being originated. And that token it travels with a telephone call from the originating service provider through the intermediate carriers until analytics companies that the carriers are using that are taking that level of attestation and deciding whether to block or label a call. So a call could get blocked there. If not blocked, then it should end up eventually with the consumer, who will be able to eventually have much more information than they do now about the call. And actually, this is something interesting worth talking about, something hopeful that's coming out of this whole process, which is the enhanced caller ID, which will give companies the ability to put more information than just telephone number. So it could be a logo of a company. It potentially even get to the point where it could provide some type of marketing text. So I think that'll make it more likely for telephone calls to be picked up.
It'll be some sort of emoji of some sort.
Yeah.
All my robocalls will have the chocolate ice cream emoji. So.
Yeah. Your emoji would probably be a shark.
It'll be a shark. Definitely be a shark.
Yeah.
Tell us about the industry traceback group that you're involved with, and why is that so important today?
So the industry traceback group is a group that is managed by US Telecom, and they are responsible for investigating complaints about calls that are originated by carriers.
And this all comes from the Traced Act, right?
Yeah, it comes from the Traced Act, which went into effect at the beginning of 2020. But how it works is the traceback group has various methods that they use for collecting complaints and also collecting pre-recorded messages. Most of the industry traceback requests that I have seen over the last, we'll probably say year, have been around pre-recorded messages. But what the industry traceback group does, if they receive a complaint or if they receive a pre-recorded message and they believe that it's illegal or unwanted, they will trace that call back to the originating voice service provider. And then they'll give the voice service provider, I think it's 72 hours to respond to the question that they have, who made the call and did they have consent to make the call. If you don't respond to the traceback group, or if the information that you provide is not adequate, that will go beyond the traceback group, because the FCC, the FTC, and state AGs have standing subpoenas to the traceback group to get the information that they collect. And so, last year you saw some. Actually, it wasn't last year. It was in the spring. Time in the pandemic has become a little crazy, but in the spring, the FCC issued threats of cease and desists to a handful of voice service providers. Those were directly as a result of requests from from information from the U.S. or the traceback group. So that request has got to be taken seriously.
So Michele, I know you are a diver as well. This is an obvious transition. I ask everyone who's a guest, what's your favorite kind of shark and why? And I know you've even done some diving around sharks as well. What's your favorite?
My coolest experience was diving in the Red Sea with oceanic white tips. And it was one of the most thrilling things I've ever done in my life. They are curious and confident sharks. And so they get within 1 or 2 feet of you. They're anywhere from 6 to 10 feet. They look like baby great whites. And we were at a dive site that 2 weeks after we left, a German diver was attacked. And the lesson you learn is you got to have qualified professionals that you're working with, because we spent hours studying how we would dive with these sharks before we dove. And really critical that you stay vertical, you don't go horizontal when you're diving with these sharks. And most thrilling. It makes you know what it feels like to be alive when you get out of the water. Yeah, that was the coolest.
Yeah, oceanic white tips are beautiful, and they are very curious, and they often get together in packs, which you have to watch out for. They've been known to attack people, but they are, we're in their territory, not ours. So, all right. Well, Michele, it's a special time of the show. Are you ready for the 5 most interesting and important and least litigious questions that you're going to be asked today?
Let's do it.
All right. Number 1, Bearcats or Buckeyes? You're an Ohio gal.
Both.
You got to pick one or the other.
Bearcats.
It's University of Cincinnati undergrad. So, all right. Number 2, calls or text?
Calls.
And why so?
Better communication with consumers. Texts in person.
Number 3, are you more a proponent of one federal regulation covering it or individual regulations from all 50 states?
The government servant in me says federal regulations. The attorney in me says state regulations.
Yeah. Better for billable. All right. Yeah, number 4.
Federal regulations are the way to go, though.
Yeah. All right. Number 4, as an attorney, you've probably watched a few attorney TV shows. What is your favorite of all time? Any of the Law and Order shows or The Practice?
Ally McBeal.
Good choice. I'll give you that. That was funny. The dancing baby. All right.
Actually, the funny thing is, though, The Practice with Dylan McDermott. My last son, so my third son, I had run out of boy names at that point, and I was watching The Practice, and the name Dylan scrolled across the screen in the credits, and I was like, oh, that'd be a cool name for a child. So he became Dylan based on Dylan.
How funny. Yeah, if I saw him, though, I would never, ever since Saturday Night Live did this, I would get him confused with Dermot Mulroney. because they did a whole bit on who is it, Dylan McDermott or Dermot Mulroney, and I don't know which one's which anymore. So number 5, and the most important question that you're going to be asked today is biscuits or cornbread?
Cornbread.
Okay. Well, you're still part of corn country, so I get that. Michele, where can people find out more about you, keep up with your thought leadership in this space, find out how to get in touch with you for legal advice and more?
So mslawgroup.com is our website, and we have wonderful blogs there that keep you up to date on all the breaking news without overwhelming you with daily doses of information. So a great place to find me and also get information about the laws that affect you.
So Michele, thank you again for being with us today on A Shark's Perspective.
Thank you, Kenneth.
So there was my conversation with Michele Shuster, a founding partner of Mac Murray Shuster, where she advises clients on proactively managing federal and state consumer protection demands. She's Regulatory Counsel to LeadsCouncil, as well as the General Counsel to PACE, the Professional Association for Customer Engagement. Let's take a look at 3 key takeaways from our conversation with her. First, as she said, there's so many regulations today. If you're not working with a smart attorney specializing in this space, then definitely consider it. General counsel at least is needed, but much of this requires a specialist because this is a very confusing area of the law. Make sure that you understand this niche because it's incredibly costly if you don't. 1, from a legal and monetary standpoint, and 2, because you should never disrespect consumers. Don't place calls to consumers that they don't want to receive. They want what they want, and we must respect that. Second, it's so important to respect privacy. Privacy was an afterthought, but that's no longer true. Privacy by design, as she said, is how we should think about honoring this request. And that's on top of how we measure required consent and the technologies we have in place. And regardless of the channel, when you collect consumer information from various sources, follow best practices and let consumers know with a single source that provides information on how that data will be used. And provide a single or at least a limited path of consent as something she recommends. Third, I listen to some marketers, especially digital ones, who don't understand this space at all, and I grow concerned about the lack of knowledge. You've got to be able to understand this and later audit this and know what you're doing, especially because, again, you're using consumer data in respect to their privacy and with how people have traditionally gotten too many calls. This is also not meant to make you over-medicate, if you will, but you have to respect consumers. Yes, it's messy to navigate, but from a shark's perspective, the best waters aren't always the easiest to find. Got a question? Send me an email to kenneth@asharksperspective.com. Thank you again for the privilege of your time. I'm so thankful to everyone who listens. Thank you to the amazing sponsors, Invoke and Drips. Please consider writing a review and letting me know your thoughts on the show. Respect consumers and respect the waters below. And please join us on the next episode of A Shark's Perspective.